Hello everyone. Hello everyone. Good evening. Can we all hear me? Hello. Good evening. Can we all hear
Yes,
me?
sir. I can hear you. Good evening.
Yes. Good evening. Thank you so much for joining us.
Good evening, sir.
Good evening. All right. Thank you everyone for joining in for today's session. We are happy to have you all in class. Okay. I think we have our moderator with us in session. I'm not the one to moderate today's session. Annette, please, if you're with us, please you can take over with the moderation.
Okay, hello everyone. Good evening. Please confirm if you can hear me. I was having challenges.
Yes, we can hear you. Please, you can go ahead.
Okay. Welcome everyone. My name is Ogona Annette Ondebu, and I'll be your moderator for today's session. So we're excited once again to gather for another JIIPCC learning experience, and as always, we have a wonderful line of mentors who will share their insights and expertise with us on today's topic. So our agenda today include mentors presentation, then mentees presentation, feedback sessions, and a question and answer segment where we can interact directly with our mentors. So let's begin. We'll begin with our first agenda, which is introduction of mentors. And it is my pleasure to introduce our mentors today. Our first mentor, our first mentor for today is Mr. Solomon Okedara. Please, once again, forgive me for any mispronunciations. Mr. Solomon Okedara is a barrister and solicitor of the Supreme Court of Nigeria, and he's a practicing legal practitioner and researcher with over 14 years post-call experience and outstanding expertise in human rights with a special bias for digital rights, including data protection and privacy, digital identity, online expressions, intellectual property, e-commerce, tech, and corporate transactions, and artificial intelligence, having an unusual knack for excellence and matchless client satisfaction with a view to delivering maximal results. Armed with a peerless ability in creative legal research and analysis, delivering impressive results in view of laws, legal principles, and standards. Solomon is a partner at Solomon Okedara and Co., a firm of barristers and solicitors, and co-founded Digital Rights Lawyers Initiative, a not-for-profit NGO that focuses on promotion and protection of digital rights. Solomon is a strategic litigation lawyer with a robust interests and proven expertise in freedom of expression, educated on digital rights and freedom of expression subjects in courts across Nigeria up to the Supreme Court, and he has conducted cases courts, among others. Solomon was in 2020 recognized as one of the top 50. Please, can you change the slide so I can continue? Okay. Solomon was in 2020 recognized as one of the top 20. Oh God. as one of the top 50 individuals leading in legal innovation in Africa at the Africa Legal Innovation Awards. Solomon currently serves as a legal researcher with Columbia University in the city of New York for the Ivy League School's Global Freedom of Expression project, where he analyzes judgment bordering on freedom of expression subjects, covering over 120 jurisdictions across the world, including United States, Europe, India, and Africa, amongst others. He is a 2016 Research Fellowship recipient of the International Center for Not-for-Profit Law, ICNL, Washington, D.C. He was specially recognized in 2017 Heroes of Human. Please, can you change it again? Okay. He is a 2016 Research Fellowship recipient of International Center for Non-for-Profit Law, Washington, D.C. He was specially recognized in 2017 Heroes of Human Rights by Access Now. Solomon was specially recognized as a finalist at the 2018 Global Freedom of Expression Prize of Columbia University. And that's it for Mr. Solomon Okedara. For our second mentor, we have Mr. Ridwan Badmus. Mr. Ridwan Badmus is a tech lawyer, multidisciplinary privacy professional, and CTO. His expertise extends across various specialized technology law domains encompassing artificial intelligence, blockchain, cloud computing, and other cutting-edge technologies. Being a certified information privacy technologist with the IAPP and an esteemed One Trust Fellow of Privacy Technology, Ridwan is at the forefront of translating privacy regulations into functional applications that handle users' data, a significant void he diligently fills. Furthermore, his unique position in working across numerous complex subjects bridges the gap between legal and technical teams, thereby harmonizing two distinct domains in this expansive technological landscape. Ridwan's ardor for the effective implementation of privacy and security best practices is evident in his active involvement in shaping industry standards set forth by eminent organizations such as the National Institute of Standards and Technology, the Cloud Security Alliance, and the Center of Internet Security. And that's it for our second mentor. I'll be reading the profile of our third mentor next, which is Mrs. Jadesola Esan. She's a corporate governance and compliance professional with vast experience in legal and regulatory compliance, risk management, corporate administration, governance and secretarial services. She's skilled in legal governance and risk advisory, contract management, data management, regulatory compliance, and secretarial practices. And we have next the final mentor for today, which is Mr. Emmanuel Ewere. He's a legal professional and compliance specialist with a strong background in information technology law, regulatory compliance, sustainability, and data protection. He holds a Master's of Laws in Information Technology Law from the University of Tartu, Estonia, and a Master of Business Administration from York St. John University, United Kingdom. Called to the Nigerian bar, Emmanuel has extensive experience advising clients on corporate governance, contract law, and compliance frameworks. particularly in the areas of GDPR and NDPR data protection laws. Wow, we are honored to have such distinguished group of professionals with us today. And the next thing is we'll go for our third agenda, which is our mentor's presentation. We'll start with Mr. Emmanuel. Sir, are you on call?
Hi, Ugonna. I'm fully here. Hello, everyone. And
Hey, it's a pleasure to have you with us here. Please, you have hello?
yes, I can hear you, Ugonna. Oh no.
I was saying that it's a pleasure to have you with us here and that you have 30 minutes.
Okay. I will spend less than 30 minutes even. And I will just touch. I've seen the presentation, and I like the fact that the whole work has been done the work has been done righteously, and brilliant submission so far. So I would just highlight certain points, and I'll wait for the discussion time so that we can actually dissect more and gain more knowledge on this. Today, we'll be looking at the rights of a data subject. And from your presentation, I can boldly say that you should be familiar with these rights. These are rights that should be manifestly done, and not just something that we read and keep aside. So first of all, everyone, just you and I, we are all data subjects, and anyone who handles our data, be it a controller, be it a processor, must, as the law will put it, shall comply to these obligations and respect these rights, which have been categorized into 8. The first one, don't forget, the right to be informed. Anyone that processes your data, I want to take us back to our first class. Whenever you hear the word procession of data, we're talking about how your data is being collected, how it's being used, how it's being stored, and how it is being shared. These are all what procession is all about. So whoever processes your data must do what? The first right is inform, the right to be informed. And what does this mean? You must tell us what the data is being used for. You must tell us who you're sharing the data with. Now, a lot of controllers have several processors in different areas. And let me break this down so that for the purpose of clarity. A lot of organizations have companies managing their data. And by so doing, when these companies collect data from the data subject, they hand it over to this other company that helps them in their data management. By so doing, they are actually transferring your data to a third party. And by virtue of the law, a data subject is supposed to be aware who the data goes to, how the data is being used, and how it is being stored. Just make me believe that my data is well secured. And lastly, the duration which you will keep my data. I believe that a lot of us have seen emails coming from different companies that you've applied for, and they'll be like, we want to seek your consent to keep your data further. If you know you've had that experience, just give a show of hands so that we can all be on the same page. Let's see people that have had similar experience. Let me see those that are responding. Perfect. Oluwadamilola, I can see that. Smart of you. Who else have experienced that before? Very good. I have Oluwadamilola that is familiar with this. A lot of employers sometimes will send you emails. We are updating our system, and we just need your consent to still retain your data for this given time. So it is required of every controller, anyone that uses your data. It is your right to be informed the duration, the length, how long your data will be stored with them. The next one is the right to access. Now, I will give an example again for you to understand this perfectly well. A lot of us have furnished our data to NIMC. And NIMC, being in custody of our data, is supposed to be ready at every given time to hand copies when we request for it. But I have seen situations where people will be requesting for their data, and NIMC will tell you, you have to pay this amount, you have to wait for this, you have to do this, and they'll tell you that no, you can't even get it in some instances. So, by virtue of the law, it is your right to access your information. That is, you can request a copy. You can request a copy of your data. And now there is an exception to this. Now, the exception is that if you are requesting on a multiple, let's say multiple copies or so, then they can actually like collect charges, because this will bring about administrative cost on them. But regardless, you still have a right to have access to your data. The next one is the right to rectification. In as much as the data controller holds your data and processes your data, you have the obligation to always prompt the controller. This is the new information you need to update. This is the new information you need to rectify. A lot of people, they have legal age, biological age, social age. When I mean, in fact, some people don't even know their age at this given time. So anytime you're changing your age, either to biological, to social, to anyone, please update a controller so that they'll have that age that you are claiming you're using at that given time. Not that today you're using 20, tomorrow you have changed to 21, and the controller is having 20. This is misrepresentation. So at every given time, you have the right to rectify your data. You have the right to rectify your data, amend, and they will update. You request for an amendment, and they will update. Another one is the right to erase. So I'll tell you another example. I think this gives clearer explanation to this. When it comes to right to erase, I remember I once applied for a job, and now this agency like they declined my application, and I felt really bad. And the next week, I saw an email, and I rushed to the email, and they were advertising other jobs to me. I was angry, like I felt bad. And after a few days, I saw another email. I checked, they were advertising other jobs to me. I was so angry, and I had to send an email to them to erase my data from their system. Like, I don't want to even remember those, I don't want to remember that particular rejection that broke my heart very well. So you have the right to request that your data be erased. I told them, erase my data. Don't send me any email again, because I know that once it is erased, they won't be able to send me any email. And they obliged and did the needful. So once you have shared your data, once you have furnished your data to any controller, and you feel that you're not comfortable with that fact, you have the right to request that data be what? Erased. The next one is to restrict processing. Just like this, the example I gave you. Now, that agency, they were like sharing my data with other employers, trying to get job for me. But, excuse me, based on my broken heart and disappointment I got from that particular one that I missed out, I was not ready to go further with them. So I was like, stop processing my data, stop sharing it with other employers. So I also restricted processing, and I also asked them to what? Erase my data. So remember, you have the right to restrict processing as well as erase data. The next one we'll look at is the right to data portability. The right to data portability. I will share you another instance again about this. So I graduated from Madonna University, and back then, when you want to request for transcript, you will sweat before you get that transcript. How many of you have experienced like real trouble with your institution trying to get transcript or anything like that? Let's see show of hands again. I'm checking to see those that, yeah, Fortune, nice. Who else? Perfect. I have Fortune to bear witness to that. Very good. Fortune, I won't forget that name. So just to get your transcript, you will apply, and they will start playing some kind of Ghana football with you. And at the end of the day, in fact, you may not, you may miss out of what you're trying to achieve with that transcript. Now, this is a clear example of data portability. Data portability means that data that the controller holds of you, you have the right to request that data be transferred to another controller or another processor. And it can be transferred in the form which you required. Soft copy, hard copy, give it any form. I have given you a very, very simple example on how to understand the concept of data portability. A lot of people have really confused data portability with data minimization. But right now, I have given you an example of how your transcript with your higher institution, transferring it to another. Imagine, okay, yeah, people like Emmanuel that loves education so much. In fact, I have all my life, I have always been learning. That is why my my biography keeps changing. Like, so in as much as I want to enter any institution, I will request transcript from my alma mater, that is Madonna University. So that early instance was really trouble for me. But with time, I guess their system is getting better now. No need to call somebody in school there and start chasing it. Now you can just go online, apply, get a tracking code. Very good system. Well, that's improvement. So you have the right to transfer your data from one controller to another controller, from one controller to another processor. That is data portability. The next one is the right to object processing. Now, you have given out your data and you discover that this organization, their system is not safe. You don't trust their storage system. You can object to the processing, or in an instance where the organization is using your data for marketing purposes, you have the right to object to that processing. And the last one is automated decision making. Now, we have come to a time where AI does a lot of things, especially for recruiters and big companies. What they do is that they just collect bulk of application and they'll hand it over to AI to start screening, and at the end of the day, they'll just pick like 5 or 10 persons and they'll call them and interview them. Now, it is the right of every data subject that you should not be, in fact, let me use the proper word, you should not be judged solely by AI. There should be human input. That is the right to automated decision-making and profiling, that you should not be judged solely by AI. There should be human input. In as much as AI will review those CVs, there should be human review as well. This is the simplest form I can break this for your own understanding. So I have taken out my time to explain this right, and I've given you instances where where it has been demonstrated. I will leave the other parts for other moderators to be able to share more light, and we will have further discussion. Thank you very much. Ugonna, back to you.
Thank you so much, sir, for that very insightful presentation. I learned a lot. I don't think other mentors are currently on call, and in their absence, we'll proceed to our mentee's presentation. So each group is going to present their work, and it will be followed by feedback from our mentors. Let's start with the group one, and each group one, are you? Group one.
Ready? I'm the presenter for group one. I'm just trying to share my screen.
You have the floor. Okay, you have 7 minutes.
Can everyone see my screen?
Yes, I can. We can.
Okay. Hello everyone. My name is Miriam Ayenowe, and I'm the presenter for group one. So I'm here to feature our presentation for data subjects rights, comparative analysis. So let's begin. We'll look at the overview of data subjects rights, the comparative analysis, impact of emerging technologies, its legal implications, challenges of implementing the data subjects rights, and the role of data protection authorities. So as we all know, currently in the digital age, it is evolving, and we cannot deny the proliferation of activities online. Nowadays, people and businesses are moving their activities online to the cloud, and though it is easy and it is convenient, granted, the one implication is that for every activity that we do on the internet, it could be something as small as signing up for a website, signing up on a new app, shopping online, we leave behind a digital footprint. We leave behind a digital souvenir. So as of now, there's like a vast repository of information and data about us online. So we're not just citizens anymore. They're what we call netizens, users of the internet. And because the same way we have in the physical world, we have fundamental rights that are granted to us that we can enforce whenever they are infringed. So also in the digital world, that is how we have digital rights. So data subject rights are basically just an extension of your physical fundamental human rights. Look at them like a bill of rights for information. It's a safety net in the digital space that ensures that organizations don't just do whatever they want with your data. So who is a data subject? A data subject is anyone whose personal data is being collected, processed, and analyzed. That could be like direct identifiers like your name, your phone number, your email address, or it could be data that cannot necessarily be used to directly identify you, but in permutation with other data, it can be can be linked to you. So once any business is collecting this kind of data that can be linked back to you, you are a data subject to them. And you have data subject rights. And as such, they have a legal obligation to protect those rights. So why are these rights important? First of all, for empowerment and control. Right now, with the way the digital world is evolving, there's currently a rise in big data. And that's because currently data is like a resource akin to oil. You will see them saying data is in oil. And why? Because businesses have now found a way to leverage this data into improving their products and services. They collect, they analyze, they process this data so that they can personalize their customers' user experience on their products and services. So because they're in custody of this data, it is necessary for the data subject to have rights so that they can be able to have a say in the way these companies use their data. So there's also transparency and accountability for the fact that these businesses, they collect your data, they are obliged, they are required to tell you what they do with the data. It enhances, transparency. It enhances it holds them accountable. Because if this data is mishandled, if it is mismanaged, if it falls into the wrong hands, it will have real life adverse effects on you as a data subject. So these rights grounds them in accountability. And there's also legal protections. The rights, like I said, they are a digital extension of your fundamental human rights. So they are not just theoretical, they are backed by laws. And as such, if your data gets mismanaged, it gets mishandled, you can seek legal redress as a data subject. And it's also trust and confidence. Right now, an organization's capability to handle like huge data set, and not just handle it, but to handle it ethically and responsibly is a competitive advantage. So when people know that their data, their information, their personal and sensitive personal information is protected around you, they'll be more likely to interact, to use your products, to use your services. If your organization is always in the news for bad data management or data mishandling every time, your consumers would literally not want to gravitate towards your products and services. So things like protection of data subject rights project your organization as ethical, project it as responsible. And because of that, it fosters trust and confidence in your brand. So what are the data subject rights like? What are you entitled to? Now, there is the right of access. So there's the right of access. Now, right of access is just basically you asking the company, what information do you have on me? Let me have it. Right of access grants you the right to be able to access your data, to be able to have access to your data, to be able to see your data. If you have an account with a telecom company, for example, you can request to see all the data they have stored on you, or your call logs, your billing information, any personal data, and must be granted to you in a commonly used and machine readable format, in a very usable format. So right to access just it gives you that right to be able to request for your data from an organization. Then there is also rights to erasure. Right to erasure just basically grants you the right to erasure basically grants you the right for your data to be erased. You can basically request from an organization for all your data in their system to be erased, for you to be forgotten. And they are obliged to grant that request. And there are 3 grounds on which this right is grounded. For example, if the purpose of processing the data that they collected of you, if the purpose has been fulfilled, they don't need the data anymore, you can request for it to be erased. If you withdraw your consent and you no longer consent to them processing your data, you can request for the data to be erased. If also your data was collected unlawfully, unethically, you can also request for your data to be erased. And this erasure does not just lie with the data controller, it lies with every other party, every other third party that the controller shares your data with. So once you request your right to erasure, once they erase your data, they have to notify other third parties that they share your data with to erase your data too. So this one even puts a new responsibility on data controllers to operationalize third-party notifications. And there is right to data portability. Data portability is just basically giving you the right to be able to move, to copy, to transfer your data from one controller to another, from one IT environment to another in a safe and secure manner. Imagine if you have a bank account now, an existing bank account, you want to open a new one. Imagine not just bypassing, filling all the numerous forms and processes, and then you can just transfer your data from the existing bank that you were using it to the new bank. That's what data portability entails, the right for you to be able to move your data, for you to be able to copy your data, for you to be able to transfer your data from one entity to another. Then there is right to restrict processing. This one grants you the right to tell to request that processing be stopped on particular data of yours. You're not necessarily erasing your data. You're just restricting processing. Don't process this particular data. That's what this right grants you. And there is right to be informed. Right to be informed is like a know what's happening right. It means that the organization that is collecting your data, they have to tell you what they are doing with your data. They have to tell you what they are collecting, what data of yours they are collecting, why they are collecting it, how they plan to use the data, who they will share it with. So if you notice, when you browse online, if you visit a website for the first time, you'll see this banner that pops up. It's called a cookie banner. Cookies are just basically things that enables a website to remember you, to remember your computer. So it will save things like your login details, your search history, reading history, every other thing, your cart details and stuff. That's cookies. So there's a thing that this banner that pops up. It's called a cookie banner. You can accept all cookies, reject all cookies, or you can see all information. If you click on see all information, it's going to direct you to like a cookie policy. That cookie policy is going to tell you what data of yours they are collecting, how they are going to who they will share your data with. So that cookie banner is just one of the ways that organizations feel it's right. And there is rights to rectification. If an organization holds incorrect or inaccurate data of yours, you have the right to request it to be rectified, and it must be rectified. And why? Because inaccurate data can actually have like serious ramifications. So basically, like our mentor said, you are meant and they update. So there's also right to object. Right to object is just basically you have the right to tell them you don't want your data processed in this manner. And usually these rights is really exercised whenever it comes to things like direct marketing, targeted advertising, profiling. You have the right to object. Once you opt out of, for example, if you signed up to a new app and they're sending you like promotional emails and messages, once you opt out, you object to the processing, and as such, they're supposed to stop that process. And there is right to related to automated decision making. What's automated decision making? Just basically decisions made solely by automated systems. And usually this is used because nowadays companies use AI to automate a lot of their administrative tasks. So this is using things like hiring processes, medical diagnosis, recruitment stuff. So you have the right not to be subjected to automated decision making. And if you are in fact subjected to it, you have the right to request a human review. If you apply for, if you go online now on a digital lending app and you apply for a loan online, and the automated system, just assesses you and rejects you based on, let's say, like incomplete credentials or just on some unfair grounds, you have the right to challenge that decision and to request that that decision be given human review. That's just basically rights related to automated decision. Then judicial decisions on data subjects, right? Judicial authority. This one is the Digital Right Lawyers Initiative and LT Solutions Multimedia. This is actually one of the landmark cases that conferred constitutional status and right to privacy. So in this case, the defendants, they offered for sale the data and international email addresses of like 200 million Nigerians. And what happened here was that this suit was instituted as a traditional fundamental rights case. So the issue was if they can bring the right to privacy as a traditional fundamental rights case. And what happened here was that the court ruled that the right to privacy, it is entrenched in the Constitution. It is in Section 37 as we all know, it is entrenched in the Constitution. And so the court broadened the interpretation of that right to also extend to right to privacy, right to data protection, right to privacy when it comes to your data. So this case actually conferred constitutional status on the rights to privacy in Nigeria. There are also other cases like the Medical and Dental Practitioners Disciplinary Tribunal and Concord. That one was where a patient got his medical details disclosed without his consent to his employee. And it was one of the cases that cemented where that consent is needed and when it comes to data privacy. Then go to impact of emerging technologies on data subjects, right? So as we know, technology is evolving faster than a law can even keep up with it sometimes. And though emerging technologies, emerging technologies like AI, like the blockchain, like the Internet of Things, they're very impressive, very convenient and others. But though they offer great benefits, they can also create like new challenges. And what are these challenges? We have bias and discrimination. AI systems are underpinned by data. So they learn from the data sets that they are trained on. And if those data sets reflect biases or prejudices, the AI output is going to reflect the same. Then there is also the lack of transparency when it comes to AI systems. It's one of the reasons why AI governments warrant explainability of AI. Why? Because AI systems sometimes can be complex, they can be opaque in such a way that even the AI actors themselves, for example, the developers that developed and deployed the AI, they might not be able to explain how the automated system arrived at that conclusion. So things like this can hamper your right to explainability as a data subject, especially when it concerns automated decision making. If an AI makes a decision that affects your access to the socioeconomic benefit, and no one can explain how it goes to that decision, how do you enforce your right as a data subject? And there's also data and privacy risk. So we have technologies like Internet of Things and cloud computing. They collect data, but at the same time, the massive amount of data they collect makes it prone to privacy breaches. When you even also consider the blockchain, it's secure. And one of the features of the blockchain is immutability, which is very laudable, but it raises serious considerations when it comes to enforcing your right to erasure as a data subject. Because once the data is imputed, it cannot be altered, cannot be removed. So how do you enforce your right to erasure, your right to be focused? Then we also have difficulty exercising rights. For example, how do you delete your data from an AI system? Who do you contact when your data is used unfairly? So a lot of these laws are still trying to catch up to these technologies like artificial intelligence, Internet of Things, and because of that, it's making it difficult for individuals to enforce their rights. But despite the risks, we can still say that there are some good parts of it. There are still some areas in which these technologies, they enhance data protection and by extension, protection of data subject rights. How? We have improved data quality. they're using AI now in the automated system. AI can detect correct errors in the data set, in the database. So even before the data subject flags the error, they can detect error in the data and they can correct it. Then there is also enhanced data security, stronger security measures. Right nowadays, cybersecurity teams are actually leveraging AI when it comes to threat intelligence. They use the AI to study, to learn from cyber attacks, to learn from patterns in cyber threats, and to flag them timelessly. Then there is also personalized services, like I explained before, because it's like a large repository of information platforms. Businesses are now using data to gain data-driven insights so that they can improve their product user experience. So basically, AI can customize user experiences. You can use AI to get insights to be able to customize and personalize your product experience for your users. And there's also increased efficiency. When it comes to compliance, AI has actually been very useful. AI automates things like data subject rights. In fact, some companies have AI chatbots for you as a user to be able to, make data subject requests, like request your data, request to delete your records, to update your information. So all these things make compliance easier, faster, and more efficient. So, but to balance all this, is going to have to be mitigation of risk. And how do we enforce that? How do we implement that? We ensure fairness and privacy when it comes to these emerging technologies, like AI now, for example. There should be transparency, there should be explainability. AI should be trained on diverse and unbiased data sets. And companies and these organizations should be able to make clear explanation on how their AIs make decisions. And there's also implementing robust data protection measures. This one is entrenched in data protection regulations. It's the fact that companies, organizations that or data controllers, they should be able to put in place technical and organizational measures to protect the confidentiality, integrity, and the security of data, modeled after the CIA triad. And what are these technical measures? These technical measures can include things like encryption, pseudonymization, anonymization, providing multi-factor authentication for users, things like this. Organization method will just basically include, conducting regular security audits, conducting assessment, things like privacy impact assessment, things like data protection impact assessment, especially when you're using like a new technology, undertaking a new type of processing. Appointing data protection officers. These are organizational methods and measures. So organizations are obliged, they are legally obliged to put in place these frameworks so that they can ensure data security. And by extension, protection of data subject rights. And there is also empowerment of individuals. Now, individuals should be able to have easy ways to exercise their rights, to exercise their data subject rights, especially when it comes to AI-driven systems. Organizations should also make it easy for them. They should provide opt-out options for individuals. There is also strengthening of regulations. So that's developing clear regulatory frameworks. So basically, the government should set clear guidelines for how data should be governed to protect these data subject rights. They should set clear governance for AI and for data protection. I think one of the data protection regulations have actually done well in this area because they actually not just put in clear guidelines, they've put strict penalties for companies that violate these data subject rights. So let's go to legal implications of the data subjects rights. Now we talk about legal implications of data subject rights. What the existence of these rights, what do they mean legally? Number one, they mean regulatory compliance and penalties. It enforces, it ensures that companies and organizations comply with data protection laws, lest they face heavy fines or they face sanctions. Under the GDPR, it is 20 million euros or 4% of a company's gross annual revenue of the preceding financial year, whichever is higher. In Nigeria, it is the same thing to I think 10 million or 2 million or 2% of the company's annual gross revenue of the preceding financial year, whichever is higher. So the existence of these rights can motivate companies to comply with data protection laws. Then there's also litigation and legal liability. For the fact that these rights exist as data subject can enforce this right. They can sue whenever there is mishandling or mismanagement of their rights. It could even be a class action. And not just suits, they can also seek compensations for like financial loss or emotional distress. Then there is increased organizational accountability. This increased organizational accountability just ensures that companies put in place the right measures to comply, the right internal policies, internal controls, internal processes, internal systems to ensure compliance with data protection laws and protection of these rights. And how do they do this? They appoint data protection officers. They do things like conduct assessment, conduct impact assessment, conduct risk assessment to be able to identify loopholes or to be able to identify blind spots where privacy breaches can occur. They keep detailed records of how they collect and process data, proper records of processing activities. So measures like this can ensure companies do the NIF, companies follow the law to the letter when it comes to data subject rights. And there's also reputation and business risk. Like I said before, organizations are now using their ability to handle data as a competitive advantage. So where you as a company, you mishandle data, you lose customer trust, you lose revenue. If your consumers don't feel like they are safe, their information, their sensitive information is safe with your company, they are more likely to gravitate towards your competitors who offer better protection and better business. So non-compliance and non-protection of these rights can lead to bad business. Then there is also cross-border data transfer restrictions. So now companies must comply with strict rules when they are transferring data amongst countries. So it actually helps to ensure that companies are diligent and they are meticulous when it comes to cross-border data transfer in a secure and a safe way. And there's also AI and automated decision-making risk. Because right now, a lot of companies are leveraging AI to perform mundane administrative tasks. So because of that, it is imperative for the companies to follow the proper security measures so that they can ensure fairness and transparency whenever they are using AI systems. Because these AI systems can cause bias sometimes. So you wouldn't want the automated system to make a decision that could have real-life adverse effects on the data subject. Then there is cybersecurity obligations. So companies would also need to secure personal data using technical and organizational method and measures so that they can enhance the integrity, ensure the integrity and the security and confidentiality data that they have. So basically, these data subject rights just they place certain responsibility on companies to be ethical, to be upright in their handling of that. So what are the challenges in implementing these data subject rights? We have things like low awareness and digital literacy. So like it or not, there are actually people that do not know that there is an existence of, there are people that do not know that there is an existence of a data protection act. So people do not know that their data online actually requires protection. So people do not know that they do in fact have rights. And even the ones that know they have rights, they don't know how to enforce it. And because of this, companies can easily exploit this ignorance. They can make it difficult and they can just be non-compliant with these laws. So these are one of the challenges in implementing DSR. And then there is also non-compliance with organizations. A lot of organizations, they fail to comply with these data protection laws. And mostly you see this happening when it comes to big industry giants. Do you understand? They fail to comply. They just do the bare minimum just to keep themselves out of regulators' bad books, but they don't embed ethical data protection practices in their organizational culture. So basically, most of them, what they do is that they just ignore data deletion, or they just generally ignore data subject requests, or sometimes some of them will just hide behind like complex policies so that they can delay or refuse compliance. I don't know if you heard of the WhatsApp case the WhatsApp privacy policy case in 2021. What happened in that case was that WhatsApp amended their privacy policy applicable to Indian users. Now, because of the event of WhatsApp business and using WhatsApp for business and for payments purposes, it has now increased the range of information that WhatsApp collects to financial data. So when they amended that privacy policy, it stated that they can now collect the personal and financial data of their users. And most of the users were not happy with this. They protested, but the platform gave them the stark choice that they could either accept the policy, like comply with the policy, that's accept the policy, or they will not be able to use the app. So when they were sued, when they sought legal redress, the court now ordered WhatsApp, the court instructed WhatsApp to now put out a statement to make it known that users do not have to comply with that policy before using WhatsApp. So things like these are ways in which organizations evade compliance with data protection laws, and by extension, violate data subject rights. And there's also conflicts with other legal and regulatory obligations. Most of these laws.
Hello, Mario. I'm sorry to cut you short, but please, can you try to speed up your presentation?
All right. So there's also conflicts with other regulatory obligations. Most times, these data protection laws, they clash with other laws. For example, look at the right to erasure. So that right to erasure is subject to the law. So if a law mandates an organization to keep your records for a particular period of time, they do not have to erase it immediately. And there's also third-party processing. So where all these organizations, they outsource their processing to third parties, makes it harder to track data usage. And even when it comes to cross-border data transfer, it can bring up jurisdictional conflicts legally. Then there is a lack of clear guidelines for handling this. Most of these organizations, they don't put in place clear guidelines for handling data subject requests. In some jurisdictions, data subject requests have to be replied to within 1 month. I don't know if Nigeria has that, but in other jurisdictions, they don't have such clear parameters. So there's the role of data protection authorities. What are data protection authorities? Just basically government bodies that are put in place to ensure that these data protection laws are followed to the letter. Now, what do they do? What are their functions? Monitoring and enforcement. They ensure that these data protection, they conduct audits, they conduct inspections to ensure that organizations follow data protection laws. So if a company fails to protect its personal data, they can issue fines or they can force them to change their practices. Then there's also handling complaints and investigations. They can report individuals. If you feel like your data has been mismanaged, you can report to a company handling the data. The company will data protection authorities will investigate it. They investigate like things like data breaches, unauthorized data sales, failure to honor data subject rights, things like that. They also issue guidelines and regulations. They create rules, best practices, standards to help these organizations comply with the law. The Nigerian Data Protection Commission just launched the guide, the General Application and Implementation Directive. That's an example of that. Then they promote awareness and education. They make an effort to educate the public about their rights and how to exercise them. They train businesses in data protection compliance. Like the Nigerian Data Protection used to organize occasional workshops to teach companies about the acts and their obligations. So now a comparative analysis of DSR across jurisdictions. So sorry. Now, not all data protection laws are the same. They're not the same across jurisdictions. Why some jurisdictions, they have laws that are stricter, others have laws that have loopholes. For example, look at the European Union. Let's start with the European Union, global model. Like their Data Protection Act is very comprehensive. It's the most comprehensive and influential data protection act in the world. And it grants all the data subjects rights. Like there's full rights coverage. They even have heavy fines for violation of rights, so they ensure enforcement, and it applies globally. So as long as you're processing the data of a European Union citizen, you have to comply with the GDPR. The only downside to this law is that it can be very, very complex for small business to implement. Then, sorry, we have the Indian Data Protection, Digital Personal Data Protection Act. It's new, but it's still evolving. It covers all the rights like access, correction, grievance, redress for violation. Then companies must also seek users' consent before they process your data. So India operates under the opt-in consent regime. One weakness about the Indian DPDP is that the government agencies are exempt from compliance. So things like this can result in like mass surveillance or weak enforcement. Then you have South Africa. South Africa's data protection law is developing, or it is strong. It's like it has rights. It accords you data subject rights like access, correction, objection, erasure, rectification, and stuff. And they also give citizens direct control over their data. It applies to public and private entities. So that is the South African Data Protection Act. Then there's the China Personal Information and Protection Law. The one thing about the China Act is that it is one of the strictest regulations. It is very, very strict. Although it grants rights, but it's really strict, and its compliance is more challenging than that of the European Union. So for the China Act, it ensures all these rights like rectification, access, deletion, and others. However, the China Act implements data localization. Data localization just states that data should be stored or kept in a specific jurisdiction. It should not be transferred, should not be processed or stored outside that jurisdiction. So that's just data localization. Most countries, they implement this basically just for data sovereignty, so they can have visibility, control over their own data and govern its use, and as well as preventing foreign entities from being able to access their citizens' data. So that's China's Data Act. However, it is heavily government controlled. So when the state is usually involved, the citizens' rights are usually limited. And there's also the Californian Act. The Californian Act operates under the US. The US has no national law for data protection, but different states like California, they have their own Data Protection Act, like the California Consumer Privacy Act, the California Privacy Rights Act. So it grants rights just exactly like the other laws and everything. But because the US regulatory landscape is fragmented, your data subject right usually depends on the jurisdiction. So I talked about this. So basically, conclusively, from what we've discussed so far, we can see that privacy generally is not a luxury. It's a fundamental right, and it must be protected, whether physically or digitally. So there is need for for the law to be stronger, for the law to be enforced more strictly, and for us to hold these organizations that hold our data accountable. So right now, the question is not just if data privacy is important, it's also what we are doing, what these businesses are doing, what we are doing as individuals and businesses to protect. Thank you very much.
Thank you very much, Miriam, for that presentation. We'll go ahead to Group 2. Group 2, are you ready for your presentation? Group 2, are you with us? Anyone for group 2?
Please, who is the group presenter for group 2?
Good afternoon. Good evening. We have, I think we have, I'm trying to check the presenters for group 2. We have Pearl Kolan, who is the backup presenter. There's Eunice, I don't know, the name is not there from the group, but they're like, we have the presenter, we have 2 backup presenters. There's Oluwadamilola. Oluwadamilola is one of the backup presenters.
All right, so please, can we have one of the backup presenters step in as soon as possible, please? We don't want to spend all day in class, so please let's try and get our presentation done so that we can move on to feedback from Mr. Emmanuel, and then we take questions, have an interactive question and answer session, and then we'll call it a day.
Okay, hello everyone. Good evening. This is Oluwadam. Do you guys have the
Sorry, Mr. Damilola, we can't hear you.
Can anyone hear me?
Okay, we can hear you now.
Okay, that's fine. So I said, do you have access to the slides? Does everyone have the slides?
So please, can you go ahead and...
We can hear you now, Damilola.
Okay.
Okay, go ahead with your presentation. Just start. I will try and see if I can help you share.
Thank you. So we're supposed to talk about the data subject rights in Nigeria. So this
Please remember
presentation,
to stick to time.
yes, so please, this will cover the introduction, legal framework and compliance challenges, cultural and socioeconomic factors, then case studies. So since we've covered most of the introductory part, I'll cover the legal framework and compliance challenges. So as we all remember, the rights are rights to be informed about data collection and usage, right to access personal data held by organizations, right to rectification of inaccurate or incomplete data, right to erasure under specific conditions, right to data portability, and right to object to data processing. For the most part in Nigeria, the legal and framework really comprises of, the Nigerian Data Protection Act, the Constitution, the Cyber Crimes Prohibition Prevention Act, and the Nigeria Data Protection Regulation. Now, most of these things are actually enforced, but like most legislations, most of the issues we have are, we have little to no awareness until recently, really. Most people were not in touch with their data rights, but more people are towards that. So it's very limited in the sense towards the legal ilk of Nigeria, because the average people don't entirely understand what data rights are. For the most part, people still read terms and conditions haphazardly. So aside from that, we have limited enforcement. We have inadequate data security measures, which is in fact, influenced by the cost of data protection. Some organizations find it a bit expensive to actually, uphold these rights and to protect it, because servers, it's a bit of a trade. It's cheaper to sell and move on than to, just delete and move on from these things. Then judicial interpretation gaps. Well, this is not entirely, a challenge that we experience in modern day, because we have cases on data protection whereby people's rights have been reiterated and enforced. I mean, of recent, there's a case of Araka against ENET, where he was granted 3 million naira damages by the court in reaction towards his infringement of rights by a group of data controllers. If you remember what the data controllers are, and as a data subject, he came forward to them towards their use because they traded his rights. So Domino's marketing department, and despite writing, he did not it still went ahead. So what we have now is the case studies now. So we have a case where, in the case of Incorporated Trustees of Digital Rights Lawyers Initiative against LC Solutions, it's a very large case because, it affected a large amount of data subjects. We had close to 200 million Nigerians and above across international, mailing list. And as we all know, during enforcement, it's important the kind of rules that you bring the cases under. So in this case, they brought it under the FARP rules, and they contended that they didn't have the legal basis. That is LTSM. They didn't have the legal basis to process all those people's personal data. They had, in fact, not, they were in breach of their right to privacy in line with Section 37. So what the court actually did was that it was supposed to have been interpreted expansively. And what the court did that was really, innovative was they didn't just say the Constitution. They said you have to, interpret it in line with the NDPR, because it was situated under the FARP rules. And aside from that, really, that case and the earlier case I mentioned earlier, we have future trends for strengthening, because we've seen how these rights came about, what they're about, and how breach may go and what the judicial angle has been. So the trends towards this include, aside public awareness campaigns to improve upon the earlier challenge, which we stated was limited awareness. We also have strengthening the legal and regulatory framework. We have expanding judicial and alternative dispute resolution avenue. Now, why ADR comes into place? Because in enforcing the traditional rights, it takes a moment in court. Not everyone is entirely patient. So what most people do when they are bringing their data rights protection, what litigations layer, the one smart thing that they do is they bring it in line with the human rights enforcement procedural rule, which sort of fast tracks the process. But then again, this is subject to your court's availability nonetheless. Then we also have cross-border data protection and trade. So what this does is that since Nigeria is a party to quite a number of cross-border trade, it's not enough that we protect our rights within Nigeria. We also need to consider this cross-border trade. So what we can do is that balancing the need for free data flows to facilitate digital trade and protecting our personal data. Because if we don't protect our personal data in this trade, what would happen is that we won't just be suffering data rights breach from Nigerian infringers. We'll also be suffering from people who are famed for it, for instance, our certain Asian corporations, and also, in fact, other African people. So I would like to conclude is that in Nigeria, there is a need for a holistic approach for protecting the privacy and personal data of Nigerian citizens. Because in as much as the NDPR provides a fundamental framework for data protection, we also have to, look at the cultural and socioeconomic factors which influence these things. Because ultimately, a key driver of data rights infringement is trade. They just want to sell the rights and make their money and, have reach and ads and be able to inflate their figures to suit their funding needs and all those things. So as you can see from the case studies, there actually what's called remedies for these things. But, there's a bit of an urgent need because people do suffer loss. And it's not just in terms of, the nuisance of receiving ads. Sometimes your data will be used to commit offenses that you have no link towards, because everyone looks at data rights as a sort of thing as, oh, it doesn't really have large reaching. But sometimes it happens. Credit fraud scams rather have occurred whereby people's data was used as recipients of these credit fraud scams, in the sense that they sort of use your data to create a profile. Even something as simple as when you have social media profiles. I'm sure some of us have seen, the case of identity theft on WhatsApp, whereby someone is just a regular friend and one day they're just asking you for money, or you just see the number has changed and your friend is going around sending a PSA. This is why we need to protect people's data. This is why we need to protect data subjects, to see to it that we improve the integrity of our identity, we improve the integrity of our data. Because if we do not know who is who and what is what, how then can we claim to have a firm grasp on reality? That really is the crux of data protection, to see to it that what is red is not blue masquerading as red. and consent is very important in everything. So yeah, that's the long and short of our presentation. And I think one thing I would like to draw attention to is that data rights are not just fundamental rights, they're as good as our human rights because it's enshrined in the Constitution. We need to understand this when we talk about this subject. It's as good as your right to life being infringed. It's as good as your right to freedom of expression, right to press. So the reason these rights exist is because of their importance to our being. Okay. So I'd like to keep in time because where I am is quite public. Thank you all for your time and attention. If you have any questions, please feel free.
I lost you. Are you done? Okay.
Yes, he's
Just my
done.
network. So thank you so much, Damilola, for that presentation. I would have asked some practitioner because the way you practice time, you can just come as a mentor instead of as a mentee. So well done. Thank you for that presentation. We have our picture time next. So
Yeah, so please, if you have enough lighting in your background, please can you
please, everyone, turn on your video. I'm not seeing much.
Okay, please can we have more people turn on their videos? Thank you, Kosi. Thank you, Fina. Thank you, Ifunaya.
Videos.
Thank you, Merits. Do we still have more people who want to turn on their video? Please, we would appreciate that. All right, so we are done. Thank you very much. Please, Annette, you can carry on.
Oh, sorry, I didn't realize I was muted. The next thing I would have on our agenda is our mentors feedback. So I don't know if we still have our mentors on the time on the call, but based on our mentees presentation, please can we hear your feedback? What do you have to say?
It seems I'm the only one. Okay. Let me give kudos to all those that have presented, like group 1, group 2. I like the flow of the presentation, like group 2, not like repeating what group 1 have actually made out in their slides. Like excellent presentation, brilliant presentation. The work excellent, the presentation very excellent. Like you guys went really, really deep into the whole concept. And I would like to say that if you have a good knowledge of what you have presented, trust me, any day, anytime, you can stand out. Early this month, I made a presentation on similar topic at the University of Leeds in a sustainability conference, and it was so sweet to when I was listening to group 2 presenting, and it just reminded me of how I was sharing details about this concept, because there is a lot about data subject rights and the implications as well. I was thinking that we had other mentors on ground so that they will share more lights. But now, based on your presentations, I would like to just draw out some little questions, and just to see the level of your understanding. Group 1 versus group 2. How do privacy laws handle individual rights and data access request. Now let's focus on the NDPR. How do privacy laws handle individual rights and data access requests? Is there any provision in the NDPR that emphasizes the rights, such as the access request? Let's talk about it. Group 1, we're starting with Group 1.
Sorry, please, can you like I
The
didn't
the
can you
question
like
again?
explain the question? Yes.
Okay. The question is, how do privacy laws, I now made like I specified the NDPR, how do privacy laws handle individual rights and data access requests? Okay, now let me not leave it to just the NDPR. How do privacy laws, any law you want to GDP, anyone you want to use, how do privacy laws handle individual rights and data access requests?
Okay, so if I'm clear, you're asking how privacy laws in general handle individual rights and privacy rights requests.
Excellent.
Okay, I guess first of all, apart from them granting the rights to access, granting the individual the opportunity, the privilege to be able to access their data, they could also outline like a request process, like put in place like a rule book for making these requests to the data controllers, and they could also like put in place timeframes for the data controllers to reply to these requests. I know in some jurisdictions, the time frame to reply to data privacy and data subject data rights request is like a month or so. So basically, they put in place time frames for the data controllers to respond to this request, reasonable time, and then they could also put in place not parameters per se, put in place prerequisites, things that the data controllers are supposed to provide to their data that they are supposed to provide to the data subjects. Things like maybe like the copy of the data, maybe like what they are using the data for, like why they are processing the data, how they are processing data, the categories of the data that they collect. Then in case of, let's say, erasure, where the law trumps that right, where the law mandates the data controller to keep the data for a while, they also need to provide things like data retention period, like what period they retain the data and what criteria they use to determine this period, and things like information on data subject rights, because sorry, did someone want to say something? Because things like information on data subject rights, because some data subjects, while they know some rights exist, they might not know other rights exist. So things like this, then they could also put in place things like sanctions to be able to check these organizations. So basically, if requests are not handled in an organized manner, are not handled timeously, and are not handled properly, they could be fined. Then they could also put in place things like checks for how these requests can come in, things like where checks for the kind of request, like if a request is unfounded, if it's not warranted, if it's too excessive, and things like this, like there should be clear reasons for refusal of this request. So if a data subject makes a request and the controller refuses it, there should be clear reasons for this refusal. So I think these are some of the ways that I think that they can handle privacy rights request.
Brilliant. Like, this is very brilliant. Miriam, like all those in group 2, I want to see on the chat box, like just write, well done, Miriam. This is brilliant. Excellent submission. Now, the question was quite twisted, but she was able to get out the main thing that I was looking out for. And she clearly, yeah, she said 1 month, 30 days is actually the requirement. Thank you very much. Yes, I want you guys to all write, well done, Miriam. This is brilliant. Like she has made it clear that group 1, you guys are top notch. You guys are good to go. Very, very brilliant answer. Very brilliant. Like I'm really, really impressed. Now, group 2, I'll give you another question because Miriam has done justice. Now, this law, this privacy data protection laws, regulations have really impacted on marketing and sales activities for a lot of organizations. Can you tell us how? Can you give us an example? Group 2, if you don't understand the question, I can take it again. The whole concept of privacy, data protection have impacted so much to marketers and also on sales. Can you tell us how and give us example?
Good evening.
Hi.
Yes,
Lua Busayo.
sir. So
Please.
to answer that question, I would like to make reference to this recent federal high court case, and the one that involved Eat and Go, that is Domino's and Jumia. So the issue is that before the data protection regulation, we saw that once data controllers or processors get a hold of, data of data subjects, they may make use of this information, this data, to send adverts and to send, adverts. And this is what they used to, use to gain some sort of funds. This is like digital wealth. Now I realize that some of these do it without considering, one of the lawful basis for data processing, which is consent. So they just do it without seeking the consent of the data subjects. So with the coming of the data protection regulations, it has streamlined this process that before you process the information of a data subject, before you start sending such data subjects adverts, using their information like as targets of marketing, you have to get their consent. And it doesn't just end there. We realize that some certain data processors kind of hide this consent, this consent requirement. For example, you've used several apps in which, for you to say no, it's very difficult. They will hide the no in a very small side, or when you press the no, they will redirect you to another link. So these data protection regulations have ensured that he has identified that data itself is wealth, right? So it's a source of digital wealth, and just like currency, it needs to be safeguarded. So essentially, before you start sending unsolicited messages, unsolicited marketing, adverts in particular data subjects, not only must seek the consent, we must also conform with all the lawful basis of data processing and also the principles of data processing.
Like very, very brilliant answer. Like today is a very good day. This is like one of the best I have seen. This is one of the best I have seen. Your answer is direct to the point, and your answer, you using that particular case, it's a recent case because the whole case I think 2014, and that case gave us a very good insight on how companies usually use cookies and other things to monitor data subjects to give target advertisement, and also, this whole thing have been cut short based on the application of the data and privacy laws, and this has really like reduced shall I say business, because no more business as usual for them. You have made out the whole thing, and just to save our time, I just want to say that your presentation excellent, and from the way that you have answered the question, kudos to you. Group 2, well done. Group 1, I just want to tell you guys that you guys are the best. Let us see more of this next week. Thank you very much, and I'll hand over back to Ugona.
Okay, thank you so much, Mr. Emmanuel, for that presentation and for your insights. We'll go to our Q&A session. So we're going to open the floor now for questions. Feel free to ask any question you have. You can just raise your hand, you can type it in the chat box, but we'll surely address it in this session.
Please, if we have questions, please can we kindly indicate or send your questions to the chat box.
If they don't have questions, maybe I can go back to my questions. So I have questions for them, please, so that we can get more. In fact, I love the fact that is it group 1 or group 2 even went into China jurisdiction to talk a little bit about the application of data subject rights. And is it group 1 or group 2 that said that?
It was group 1, sir.
Okay. So can you just tell us a bit about what you said about China? Because I kind of, when you call China, like, it caught my attention, because I am really like, I have like a different opinion when it comes to China and their system, especially when it comes to privacy and data protection. So can you just tell us again exactly what you said about China, so that we can actually look into other jurisdiction and compare with what is applicable here at home, here in Nigeria?
Okay, so I said China's data protection law is basically the personal information and protection law, and it is actually very, very strict. In fact, it's complying with it is more challenging than the GDPR. That is actually very comprehensive. The thing with China's law is that while it grants all those rights, but it also implements data localization. And data localization is just basically, it basically dictates that data should be stored, processed, and stored and processed in a specific jurisdiction. Always likely the jurisdiction where it's originally, and it should not be transferred, it should be stored, can be processed in data centers outside that jurisdiction. So most times the reason for this localization is so that governments, so that regulatory authority, governments will have oversight and visibility over their data and be able to govern its use without without influence from any other foreign authorities, and also so that they can ensure that foreign entities do not have access or do not control their citizens' data. So it's one of the things that the China law implements data localization. Also, for China's law, they enforce strict penalties for foreign companies that mishandle their citizens' data. So basically, they look out for their citizens, like not just locally or internationally. But one thing about the law is that it is very government controlled. The government has broad control over the data and privacy enforcement there. So usually this can like hamper their citizens' rights over the states. That's just a summary.
Miriam, like I I think we should have more discussion with you. Like I am so impressed, like super, super impressed. This is good. You have
Thank you
actually
very much, sir.
you have actually nailed the point where I usually have problem with the whole China system is the fact that their laws protect against any external intervention, but there is high level surveillance on the data subjects. In fact, the way they interfere with the state interference on data subjects privacy is extremely alarming, which has really raised a lot of issues. But you are right that they have maximum protection when it comes to external. So Miriam, oh my God, I should have more discussions with you. You're fantastic, you're fabulous, you're excellent, and kudos to you. I like the way you brought out the main point about it. So personal information protection law of China is one legislation that I would say that quite differ from our own system. Okay, since they run okay, they don't run yeah, they run the communal government, and they're very, very concerned about their citizen. And in fact, they run something that they call the social credit system, where people are they're judged by your acts and actions. I noticed something recently in Nigeria that if you owe, let's say you're owing you collected a loan from which bank, which fintech will I use as an example? Let's say you're owing OPay and you want to collect from PalmPay. Now they can get your financial record from OPay and decide whether they should give you that loan. Is that happening right now in Nigeria? I want us to interact. Group 1 and Group 2, we are interacting right now. Is this happening in Nigeria? Hello, can we unmute
Yes,
so that we
sir.
can
Yes, sir.
talk?
Technically, sir.
Why do you say technically?
Because for some of the loan apps, they can check the credit registry. However, it's not all of. However, there are still some. They are still lagging with it because they may not be able to see all the data, but the credit registry has some data of credit defaulters and their history.
Perfect. Okay. Thank you, Suleiman. Thank you very much for that observation. So now the question is it a violation of your privacy for them to disclose your financial record without your consent? This question is open to Group 1 and Group 2. Is it a breach to your right to privacy that they are disclosing your financial record to another bank without your consent? Let's get answers from all the brilliant heads. Like we have Miriam and co here today. So I need the brilliant heads. Let us interact. Last week, we talked about consent. Today, we're talking about your rights as a data subject. Come
Yes,
on,
sir.
good. Oluwabusayo.
Yes, sir.
Tell us something.
And if you look at the lawful basis for data processing, we have a number of lawful bases. We have consent being among them, but we also have other ones mentioned there, in which we have like public interest, vital interest. So while ordinarily it will require your consent for them to transfer your financial records, but only if they can come under these other bases, probably for public interest, probably someone has been for the purpose of national security or for the purpose of judicial proceedings, that because has ordered that his financial record released for the purpose of for that purpose, or maybe for criminal proceedings. But naturally, originally there should be consent before you could transfer someone's financial records to a third party. But then we also have other lawful basis. We also have legitimate interest, and that is the legitimate interest of the data processor or data controller. But however, if you look at that legitimate interest, it should not, we must not be against other lawful bases. So in as much as the data processor or data controller might have reasons, it should have to just oppose it with the other lawful basis. So there's not just a direct answer to it. So while largely that it has to be their consent, but then there are some other situations that can come up that the data processor without the consent might still be able to transmit the information to a third party.
Busayo, smart. Very smart of you. I like the fact that you tried to bring in legitimate interest to buttress your points. Who else? Let's hear from someone else. Like, I'll come back to you, Busayo, on that. This disclosing your financial record to a third party without your consent, is that a breach to your privacy rights? Who else can share something? Let's hear from someone else. Smart of you, Busayo.
Okay, good evening, sir.
Hi, Merit.
Good evening. I personally said you did not really bring in any exception with respect to the other reasons why concept should be override, like the issue of court ordering, public interest, and all. The question is very straightforward, and you said OPay, transferring your financial information to PAMPay or something of that nature. Now, your financial record is a sensitive one. I believe most of us, even when we are broke, we still want to maintain our confidence that we are good. Okay, so it's a very sensitive record that should not move without sense. Usually, when we have these issues of wrongful transfers and all, if you go to bank and you're just asking the bank for maybe phone number of the person to reach out to the person and tell the person, okay, transferred money to your account, can you transfer it back? The bank will not do that because it's sensitive, it's personal to you. Okay, so what bank will always tell is go and get a court order. This court order will help them to do whatever they want. So if my personal information with OPay is transferred to maybe PAMPay or any other bank because they want to know whether I'm credit worthy, that is not right. There are other ways you can do due diligence to find out my financial record and my financial credibility. So if they by chance do such thing without my consent or without following any other procedure that will give them the legitimate right to do that, like obtaining a court order to that effect, it will be a breach of my privacy rights, and I have the right to take actions with regards to that. That's my response. Thank you.
Another smart one. Merit, that was nice. Okay. Just like Busayo said, like you can fall on any side and you're making a point. But let me tell you something. Who is OP? Now who is OP? OP is like a controller that you as a data subject, you'll furnish your data to, and they are now giving it to another controller without your consent based on our system. Now, this is not the Chinese system. This is not the GDPR or any other law. Now, where there is such violation, first of all, without any exception, without relying on legitimate interest, now there is no issue of national security here at all because it's my financial record and they're not investigating any crime. So this is because I want loan. So there's no crime here. So you cannot rely on legitimate. Let's put aside the exceptions first. In the first, looking at our own system, looking at the NDPA, the Nigerian Data Protection Act, without exception, generally it is a breach. But there are exceptions where they can rely on. So let us look at some of the questions that have been listed. He said, what are the main enforcement mechanisms available to data subjects in different jurisdictions? Let me just focus on Nigeria. Now, we have an elaborate law right now. We have a very good regulation governing privacy and data protection. But one of our biggest challenge right now is enforcement. The NDPA has actually made out a provision for the commission. The commission is supposed to be the NDPC. That's the Nigerian Data Protection Commission. And they have made out certain fines and penalties that organizations are supposed to pay when there is a breach to data subject rights. And this penalty can go as high as 10 million naira. Or they can even, this penalty can be like 2% of your annual gross revenue. So it depends. So I want you to know that now we have the laws. Let's use on paper, we have strong penalties that have been made out where there is violation to data subject rights. And also, remember, I just told you that there's a penalty for up to 10 million, or you can pay 2% of your annual gross revenue. That's if your company earns so much and they see that, in fact, 10 million will not even shake you guys. Let's use an example like MTN. MTN paying 10 million will not even, in fact, they don't mind. They can even bridge more. So when they see that big companies like that are violating data subject rights, they can go for 2% of their gross revenue. And as a data subject, you have the right to seek redress where there is violation to your rights. A lot of we know the stress, how long it is to take up cases in Nigeria. But I want you to know that right now, the court gives accelerated hearing to a lot of matters bordering on privacy and data protection, because we need to build judicial cases and precedent on this particular issue. Now, when you look at enforcement in Nigeria, I'll also Yeah, let's look at some criminal aspects. You should know that right now, a lot of people prefer going to the police or EFCC even to enforce the Cybersecurity Act. In fact, recently on social media, someone was sued for cyber stalking. You guys are familiar with that? So there is a criminal aspect to seek redress as well. And now let's look at how our judiciary, how they have actually approached matters like this. Though we have had a lot of conflicting judgments. Last week I told you about a case where the judge made out certain parts that a lot of us, I am actually included, did not really like agree with the judge where he said where he made out the fact that the data subjects are actually the controllers when it comes to subscribing to an application. You know, we have a lot of conflicting judgment, but we believe that by the time these cases, once we start getting judgments from the Supreme Court, now this will form strong judicial precedents for us to be able to, you know, gain like better legal interpretations. And if we look at the EU GDPR, there is a very, very strong enforcement and implementation. Now, you know, there is very big difference between having these laws and also implementing the laws. So if Nigeria can build their enforcement capacity, when I say enforcement capacity, the NDPC, the commission should be empowered to implement not just having it in paper, but put in a lot of implementation. Let us see companies being fined. Let us see controllers. Let us see controllers scared of playing with data subjects, data, scared of selling data, scared of even oh my God, even our own system, even NIMC, they can't even protect our NIN. So I don't even know if the government can actually look at private organizations. And if you look at the role of international organizations, we have Nigeria is a signatory to the Malabo Convention. And that convention is more like an African Union Convention on Cybersecurity and Personal Data Protection. So I think that Nigeria can also they are not bound by such organization, but this organization, they serve as advisory bodies that can help us improve our data system. ECOWAS as well. ECOWAS has a data protection regulation as well, which is harmonized for West Africa. So Nigeria can also pick advisory as well. We're not bound by such regulation. They act as advisory to us as well. And I give example of our BVN and NIN, how NIMC have not really given us confidence. We don't trust their system of security. So we believe that there is need for improvement there as well. Then role of international organization, ECOWAS can help, Malabo Convention can help as well. And though we have a lot of copy and paste from the GDPR, I think that we should copy and paste the enforcement as well. We should not just copy what is contained in the GDPR. We should learn to practice the way the GDPR is being enforced. So, I have taken much time on this. Ugonna. Thank you. Thank you everyone for your presentation today. Thank you so much for your brilliant answers. Like, I'm so happy today. Miriam, I will reach out to you on LinkedIn, and you guys, all the best. Thank you very much.
Thank you so much, sir, for engaging us and giving us your time. It's so appreciated.
Hello?
Thank
Hello?
you, Mr. Solomon. We can hear you.
Good evening.
Mr. Solomon is here.
My Oga. I joined quite recently and I enjoyed your submission. I don't know if I can still make a few contributions. Hello? Can I still make a few contributions?
Yes, sir, you can.
Mr.
Okay.
Solomon, we are always ready to learn from you.
Thank you so much. I'm honored. Okay, so quick one. Yes, most of the questions are quite are interesting, but I think I found it most interesting, the issues as to enforcement. Perhaps the reason we have it as the first question. Okay, so for me, I think the first question I have issue with is, let's look at enforcement of privacy and personal data from both civil perspective and criminal perspective. Just like my God said the other time, he did not only dwell on NDP, he also made mention of the Cybercrime Act. I'm sure you need to understand that the Cybercrime Act also, particularly in section 37, also, no, 38, also seeks to protect your right to personal data. And of course, this time around, when your right to personal data is violated, the perpetrator, the person who violated that right is subject to criminal litigation and can be sent to jail. However, I have my reservation with how that is done, because that actually gives the provision of protection of your right under the Cybercrime Act is actually subject to violation by the state authority itself. I'm talking about the police, for example. So, and in taking you to around that, if you look at it, the provision of section 38 before the amendment is to the effect that the police can actually, the police or any state authority can proceed to violate your rights if the detection of crime, investigation of crime, and all of that, without any judicial oversight. I am saying it is also important to ensure that the court is given a role to play in this. Anybody who is close or who has a relationship with anybody in the police authority can get the police authority to write and say they want to investigate your social media account without any actual commission of any offense. That's number one. Number two, can we even talk about the jurisdiction of the court under the NDPA? May I actually throw that question open? Which court has jurisdiction, subject matter jurisdiction under the NDPA? Can somebody tell us? Can we learn?
I don't know if I can answer that.
Yes, please go ahead.
And if you clearly look at the provisions of the NDPA,
Yeah.
it merely mentions courts, right?
Yeah.
So it does not tell us which courts. However, we can also take an idea from the provisions of the Constitution that deals with jurisdiction. So if the whole data privacy, the whole data protection breach happens in the workplace, then we can bring that under the National Industrial Courts. But then outside of the workplace, where do we institute it? Now, most times you see most of these data protection cases being held in the Federal High Court, because most people look at the agency, because we see that they sue federal government and its agency, that is NIMC. So they base it on that to institute the action at the Federal High Court. But then what if it's just a usual data controller without any a usual data controller who does not have affiliation with the federal government or its agency? Where do we institute it? Now, if you look at data protection, it does not fall under any of the things listed as under the exclusive jurisdiction of the Federal High Court particularly. So I think it's safe then to institute such at the High Court of a state, which has general civil jurisdiction.
Okay, so can I go to customary courts?
Well, it depends. Customary courts, the jurisdiction of customary court has to do with customary matters. So if you are saying, if, for example, maybe your data, because a data processor is not limited to, a digital platform. So if the data controller processor is a customary, maybe a traditional, maybe let me give an example. Maybe the development association, or maybe the town the town association or whatever, which can be regulated probably through customary law. Then you can, in that instance, probably bring it in the customary court.
Customary court, okay. Any other contribution? Thank you for your contribution, Oluwabsayo.
Okay.
Any other response?
Good evening, Mr. Solomon.
Good evening to you.
Hello.
I can hear you.
Thank you very much. I totally align myself with what the last speaker said, except for the last part of his conversation with respect to customary court. I think if you look at the jurisdiction of customary court, it says that they will have jurisdiction to respect to questions of customary law. And even though our customary law is largely unwritten, we know that the issue of data privacy is not something that is enforced under customary law. Okay, so I basically think that irrespective of whether it's coming between a traditional ruler or whoever traditional customary, is still something that should be brought in the High Court of the state if it doesn't involve a federal agency and not at the customary law, because customary law, customary court basically deals with questions of customary law. Thank you very much.
Okay, Merit, can I ask you a question very quickly?
Yes, sir. I'm with you, sir.
Can matters of data protection lie before the Sharia court?
Okay, I don't really know about Sharia law, but I know basically that since customary court has jurisdiction over matters relating to questions of customary law, Sharia court should also have jurisdiction over matters relating to Sharia law. I've not really read the Sharia law to know what is really embedded there, but I don't think it should be brought in that particular court. It should be something that should go to the state court. Although I know that the jurisdiction of Sharia court to an extent is what we have under customary law. I think it's wider.
So you exclude out. That's your submission, right? Do we have thank you, Mary. Do we have any other person who has a different or slightly different opinion from Busayo's view and Merit's view? Any different or slightly different opinion contribution? No other opinion, no other response, no other contribution. Can you hear me? Can you hear me, please?
Yes, sir, we can hear you.
Okay, so I said no other contribution, no other opinion, slightly different or entirely different from what the two speakers have said. Okay, so in the absence of such, let me give my view, my model. First of all, can somebody tell us how subject matter jurisdiction is acquired? Can somebody guide us? Any idea, any view, any opinion?
I want to be sure what do you mean by like the subject matter? Well, I just know that the Constitution, largely from Section 230 downwards, lists, provides for the courts and gives, highlights the matters in which these courts have jurisdiction on. So that is where we largely get the subject matter jurisdiction.
So you, okay, I really want to, so what you are doing, you are using the hammer to caress the head of the nail. I want you to go beyond caressing the head of the nail with the hammer. I want you to hit the nail on the head.
Okay, so
yes.
to determine jurisdiction, you look at a number of factors. Now, while you look at subject matter, you also look at parties, right? So who are the people involved in the matter? Is it a federal government agency? Is it the National Assembly? So you look at subject matter and the parties. And, while the Constitution has provided for it, we have cases who have also interpreted, the provisions of the Constitution. I'm not really sure I understand.
So I'm aware at time is actually fast, so let me quickly unpack. Now, so when we are talking about, so let's go back to the provision of Section 65 of the Nigeria Data Protection Act 2023. Section 65 says, court under this act shall mean any court of competent jurisdiction. Any court of competent jurisdiction. First of all, to let you know, that thing doesn't mean anything. It doesn't mean anything. It means nothing. It's just a very cosmetic phrase with no statutory usage of value. So why can we say that? Why should anybody have said that? This will answer the question. One, our courts, Supreme Court and Court of Appeal, have said that before a court can be a court of competent jurisdiction, three things must be in place. One, the court must be duly constituted. If it's a three-man bench, all the three judges must be present. Two, the court must have nothing preventing it from exercising jurisdiction. For example, issue of local standard of the applicant or the plaintiff. Three, the court must have subject matter jurisdiction on the matter. Yes, quite right. Somebody has already actually supplied us, a judicial authority on that. So subject matter jurisdiction, data protection is a matter of subject matter jurisdiction. Now, so how do we have subject matter jurisdiction? The Supreme Court and Court of Appeal also have said in a number of cases that subject matter jurisdiction is not what can be inferred by the court. No court can sit and say, I think I have jurisdiction. No. And that parties cannot confer jurisdiction on the court. But jurisdiction, subject matter jurisdiction, is a matter of express donation by the Constitution or a statute. That a court cannot say, oh, I think this court has jurisdiction. No. When it comes to subject matter jurisdiction, it has to be expressly donated by the Constitution or a statute. For example, when it comes to the issue of intellectual property, I'm sure if I ask every one of us here, nothing less than 90% of us will immediately indicate interest to respond to it, and what tell me is Federal High Court, because it is expressly provided by the Constitution. If I ask anyone here about Freedom of Information Act, we will immediately raise up our hands and tell me Federal High Court and High Court. Why? Because the statute provides Federal High Court, and High Court of FCT as court with the subject matter jurisdiction. Now, why do we have in the NDPA as any court of competent jurisdiction without specified courts that can have subject matter jurisdiction? Currently, of course, maybe some of us would have come across a case before the Federal High Court, which awaits final address, and the case of Solomon Okidara and AGA and National Assembly. When the act was passed, and the reason why that case was immediately filed when the act was passed is because modestly, I was the lead consultant to the development partners to the Nigerian government. When the Nigerian government was going to get a credit of $430 million from the World Bank, EIB, and FBA. So one of the things they required was an HRIA, yes, a human rights impact assessment, to actually assess the rate of violation of human rights in Nigeria and how execution of that project, I'm talking about your digital ID, your NIN, how executing it can violate your right to privacy and your personal data. So we made some recommendations. Of course, one of the best recommendations we have is enactment of the Data Protection Act. But beyond that, we also made recommendations that Federal High Court of State, and High Court of FCT should expressly have subject matter jurisdiction over it. Now, let me be clear here. Some person will say, okay, issues of data protection are extension of right to privacy. Yes, before the Data Protection Act, when we were litigating most of the cases, you find that data DNRI and NIMC, DRLI, and Unity Bank, DRLI, and NIS, and all of those cases. When we were litigating them, essentially on Section 37 of the Constitution, then of course the NDPR. But let me be clear. Even while the Freedom of Information Act is an extension of Section 39, the moment the Act became a subject matter legislation, it was bound to have a provision, an extra provision for the court with subject matter jurisdiction under it. And so that is why such law does not provide for any court with competent jurisdiction. No. That phrase doesn't make it. It's just a useless use or a wasteful use of a statutory provision. It means nothing. It means nothing. So for me, now so what happened when I asked the question? And all of us were saying, okay, yes, National Industrial Hello?
Yes, we can hear you now. We lost you, Faith.
Yeah, oh, I'm so sorry. I don't know where I stopped.
Yeah,
But
where you about to talk about the National Industrial Court?
oh, okay. So what I'm saying is this: issues of subject matter jurisdiction under our law are not issues that a court can guess or the parties can confer on the court. It has to be expressly provided by the constitution or a statute. Did we hear that, please? Hello?
Hello, sir.
So
Yes,
I said, I hope you got that. So, and that was actually what led to the case that was filed, challenging the lacuna created by Section 65 of the NDPA. On no account should a statute leave litigants or the court in limbo to guess which court should have subject matter jurisdiction. It's a lacuna, pure and simple. And the courts have actually ruled in a number of situations where there's a lacuna in a particular statute, what the court can do. Well, maybe the very best I can do, or maybe I can actually encourage you to do, is just to keep yourself updated. I'm sure as soon as the court delivers judgment on that case, it will go into the media, of course, and some of us can read it and know what our court has said when it comes to the issue of subject matter jurisdiction under the NDPA. But I can tell you as of today, that would, for a long time, until that is laid to rest or is amended, by the legislators, there will continue to be issue of chaotic legal education. As we speak today, some persons have gone to the magistrate court. I mean, somebody told me he has gone to Sharia court. I actually saw what the NDPC has attempted to do. So in the game that the draft game that the
I think we lost him again. Is it just from my end? Can anyone hear him?
No, we lost him.
We'll wait for a few minutes. If we do not get him back on call, then we may have to end the session.
But our time is fast spent, and I think I will just have to leave us now so that I do not further keep us here. But then I think it's an interesting conversation we should continue even in our private time and sessions. So, and of course, I will be available to attend to anybody who may have one question or the other on the subject or some other subject around data protection and privacy. Thank you for your time.
Thank you so much, Mr. Solomon. We extend our sincere appreciation to all our mentors, both Mr. Solomon and Mr. Emmanuel, for creating out time out of their busy schedule and talk to us here on this session. It brings today's session to a close. I'll always remember, share the screenshot you took, spread the gospel of JIIPCC, tell a friend to tell a friend, tell them to register. In the absence of any other announcements or any other question, we're going to conclude. Thank you again to our mentees for participating and for engaging the mentors actively. I hope to see you again in the next session. Enjoy the rest of your day.